Hi, my name is Caitlin Schiraldi, and this is my colleague Erin Earhart, and we are going to talk to you about a case that we just filed. So our lawsuit is challenging the authority of the Department of Justice and ATF to expand the congressionally defined term firearm so that it can control gun parts that Congress never intended the agencies to regulate. So not only do we have a natural right to self-defense, but freedom lovers have been personally manufacturing firearms for centuries, so well before our nation's founding. This new rule would greatly burden our American tradition of personally manufacturing firearms. The agency's final rule is unconstitutional. It violates the separation of powers by doing a job that only Congress is elected to do. And the final rule also violates the Administrative Procedure Act, which is what Congress has set out as the rules that agencies must abide by.
So Congress defined the term firearm to include the frame or receiver of a gun. For decades, the agencies have defined frame or receiver to include the part of the gun that holds the firing components. But in an attempt to undermine the right to self-manufacture that Caitlin just talked about, the agencies have rewritten the definition to include anything that can be readily converted into a frame or receiver. Yeah, that's right, anything that can be readily converted, whatever that means, into a frame or receiver is now classified itself as a firearm. But this definition is ambiguous, so ambiguous, in fact, that the government had to specifically say that literal blocks of metal or liquid polymers or other raw materials are not included in the new meaning of firearm or receiver. Seems obvious, right? Who in their right mind thinks that hunks of metal can be firearms? Well, before their oh so careful clarification, apparently the ATF and the DOJ did. This new definition defies longstanding agency precedent and congressional intent.
To add insult to injury, the agencies also encompassed within the definition of firearm weapons parts kits. So you can purchase these online today if you wanted to assemble a weapon at your house. And in 1968, when Congress passed the Gun Control Act, Congress explicitly left out weapons parts when it defined the term firearm. It would be difficult to regulate every part of a gun as a firearm. And Congress wouldn't have given the ATF such broad authority to regulate weapons parts kits without specifically saying so. The Supreme Court has said this before. They said that Congress doesn't hide elephants in mouse holes. This new definition of firearm that encompasses weapons parts kits goes to the heart of something called the Major Questions Doctrine. Now, this doctrine was up front and center in West Virginia versus EPA that was decided this past term. And the Supreme Court defined this doctrine as the idea that administrative agencies must be able to point to clear congressional authorization when they claim the power to make decisions of vast economic and political significance. So here it is clear that the ATF is trying to claim that it has the authority to make a decision of vast economic and political significance by regulating an industry that is currently not regulated because the parts that they produce are not in fact firearms. So the agencies have violated the separation of powers, congressional intent, and long-standing agency precedent.
MSLF's Center to Keep and Bear Arms is so excited to work with Firearms Policy Coalition and hold the government accountable to the law. We look forward to updating you on the successes of this case, and be sure to stay tuned to our social media channels and our website at mslegal.org. Thank you.